So estate planning one-on-one. So we're going to talk about a trust, a will, and a power of attorney. So basically the basic documents of an estate plan is three different documents. And I like to look at it as a pyramid, right? So the bottom of the pyramid is the power of attorney. The middle of the pyramid is a will, and the top of the pyramid is a trust. So just think about a pyramid. So when we do our estate, the very, very first thing we should have from a planning standpoint. Now, depending on the person's situation, you should have all the documents, but the first document that is essential is the power of attorney. And the reason why, because the power of attorney, it is a legal document that allows someone to be known as the principal, right? Or the power of attorney. So I'm giving a person the power to appoint me, if I'm the power of attorney, as agent or attorney of fact. So that agent or attorney of fact, he or she can make decisions and act on your behalf in a various amount of different matters, including financial, legal, healthcare decisions. So it's like I am able to act on a person's behalf while they're living. So very, very important. And when people kind of make the mistake, when a person passes away, the power of attorney goes away. So it's great for the power of attorney to have the power, but if a person passes away, that power goes away. And I always kind of like to use examples. Like we had a client, unfortunately passed away a few years ago, and on their bank account, they had what you call a TOD. You guys will definitely want to write this down. So a way to bypass probate when it comes to your bank account is to do a POD, and that is a power on death. And the power of attorney can do this if a person is incapacitated, which we'll talk about shortly. What the POD says is that, hey, I want the money out of my bank account to go to a specific person. That could either be to a trust or that could be to a specific person, a POD, power on death. So in this instance, we had a client that had their POD going to a family member that they no longer got along with. So the person that was sick, had this beneficiary for a family member that he put on, 5, 6, 7 years ago. Now they don't get along with that family member, but they never forgot to change the beneficiary from that family member to somebody else. So after the person passed away, the power of attorney 3 days later went to the bank, asked power of attorney with the documentation saying, hey, I want to change this beneficiary. Well, banks have a system where they're able to see who passed away and who doesn't. So when a person passes away, doesn't mean you can just kind of go to the bank and make changes. The bank knows when a person passes away. I don't know what the system is, but there's a system that they pull up by people's social security number. They get notified. Once that happens, then they actually freeze the account. So when the power of attorney went to the bank, the account was frozen. So at that time, they could not make any changes. The person got the money, and I don't know if they gave it back, but they was entitled to that money because it was a POD. So to make sure we bypass probate from a bank account standpoint, we do a POD on the bank, but we also want to make sure the power of attorney makes sure everything is in order because when a person passes away, that stops. So it grants the agent authority to act on behalf of the best principal in the scope of anything defined in the document, which we'll talk about here shortly. And it can be helpful in situations where you're unable to make decisions. We can have two different powers of a power of attorney. We can have a power when I am able and well to make decisions, or we can have the power when a person becomes incapacitated. And when you have a power of attorney document, it says on that document, do you want the power of attorney to have power today? Or do you want to have the power of attorney to have that power when it becomes incapacitated? Now, just me, Mario Payne, I typically recommend we have a person to make that decision as a power of attorney when a person becomes incapacitated, right? So like my wife is my power of attorney, right? Now, of course, what's hers is mine and what's hers is hers. But if I want to make a decision, like I want to make a decision, right? So, now if I'm capacitated, of course, I want her to make the decisions for me. So when it comes to a power of attorney, we typically recommend individuals to have the power of attorney start when the person becomes incapacitated, not when the person is still, able to make decisions by themselves. But on the actual power of attorney document, you are able to make that decision if the power of attorney starts now or the power of attorney starts when I'm incapacitated. So yeah. So kind of hopefully that kind of sets aside. But again, in my mind, you guys could put in the chat, it's called a POD, because I just got a DM, can I said it again? It's a POD, and a POD stands for power on death. So power on death. And the person now could do that if you're, alive, well, or if you're the power of attorney, you can do that while a person's living on their behalf. It just makes sure that the money in the bank account does not go to probate. It goes to who a person wants to. Now, if you set up a trust, I recommend that the POD is actually the trust and not an actual person, which we'll talk about here shortly, because with the trust, you can kind of dictate how the money is spent after I pass away. But if it's a POD, once they get the money, they get the money. So once they get the money, it is what it is. Nothing can be done. So I actually recommend a person having the trust as the POD, not the actual person. But if you don't have a trust, you don't want to do something quick to make sure if something happens, it goes to somebody and doesn't go through probate, then that's when you want to do the POD. All right, cool. So you have two types of power of attorneys. You have the medical power of attorney, and it authorizes your power of attorney to make healthcare decisions when you're incapacitated. And then you have the financial power of attorney or durable power of attorney. So durable power of attorney, financial power of attorney, same thing. And in our documents, with the relaxed estates, we have both power of attorneys. You have your medical power of attorney and you have your durable power of attorney. So you have both documents inside that. And when a person does a power of attorney package, it should be, you shouldn't just have a medical power of attorney, because you want to make sure that financial things are done as well. You don't want to just have a durable power of attorney. You want to make sure medical decisions are done well. So it grants the authority to manage financial matters, paying bills, managing investments, things of that nature, right? So when can a power of attorney be used? It can be used towards financial matters, healthcare decisions, real estate transactions, legal representatives, business operations. Another reason why it is important to have a power of attorney is because individuals get divorced, right? So by law, the spouse can make decisions. Well, sometimes when people kind of go through marital situations, they become separated and not divorced. So when you're separated, you are still legally married. So since you're legally married, by law, you are the next of kin, or you're still the person that can make decisions on behalf of the person that's sick or incapacitated. That's not good because if there's some friction there, right, the power of attorney can make decisions that the family might not want to make. The power of attorney can change things from a documentation standpoint, put themselves as beneficiaries on things that the rest of the family really can't contest. And from a probate standpoint, if things go through probate, it is the power of attorney, and the power of attorney acted on their behalf. And even though they're separated, they are legally married, which is next to kin. So another reason why a power of attorney is important, especially for individuals that's going through separation, it just makes sure that what you want to have done from a says what standpoint is done. So just very, very important. When it's separation, you're still legally married. So the spouse who is separated but not divorced can still make financial and medical decisions if the person's incapacitated. Having a power of attorney stops that. Now you can pick whoever you want to as a power of attorney. So if you are married and which we see sometimes, people might be married, but they want a brother or sister to be the power of attorney because they don't want their spouse to kind of make emotional decisions at the time of distress if a person's incapacitated. So just because you're married doesn't automatically mean you have to put your spouse as the power of attorney. Now, I don't want nobody sleeping on the couch because they put their spouse as the power of attorney. So you want to have that conversation with your spouse, but you don't have to put your spouse as a power of attorney if you don't want to. Also, with a power of attorney, you can have two different power of attorneys. You can have a primary power of attorney and a secondary power of attorney. Now, typically, the primary power of attorney outweighs or supersedes the secondary power of attorney. So let's say the primary power of attorney might be a sister, and the sister says, "Hey, I want things to be one way." And then the secondary power of attorney, which is the brother, might say, "Well, hey, I want things another way." Typically, the primary outweighs the secondary, unless you put information into your trust. So if you create a trust, when it comes to the trust, you have additions and restrictions where you can kind of pinpoint if something happens to me from a power of attorney standpoint, they have to agree on a decision, my primary and my secondary. So another reason why trust is so important, because you can also aid the power of attorneys and kind of walk them through what decisions to make, even though you're incapacitated. But typically, the primary power of attorney supersedes the secondary power of attorney. So what is the difference between a POD and a TOD? So a POD is a power on death. A TOD is a transfer on death. The only really difference is that a bank calls it a POD, which is a power on death. An investment firm calls it a TOD, a transfer on death. But it's really the same thing. You're putting a beneficiary on a financial account. So an investment firm like Truist or like TD Ameritrade or like Merrill Lynch or like Fidelity, they're going to call that document a TOD, which is a transfer on death. A bank like a Bank of America or Wells Fargo or JP Morgan Chase, they're going to call that same document a POD, which is power on death. But it essentially does the same thing. You're basically able to name a person or entity, if it's a trust, that they get the money without it going through probate. Trust as the POD, not the actual person. So yes, you could put a trust as a POD. It does not have to be an actual person. Yeah, sometimes people actually put charities. If you have a charity that you want to give something to, you can put the charity as a POD or as a TOD. Again, recommendation wise, I would say put it into a trust and then have the trust disperse it into the charity, because that's going to help the trust from a tax standpoint. But yeah, you can put a trust, charity. If you want to put your church, we've seen clients, through the trust, we've seen clients, donate money to the church. So they want to do their 10%, in life and in death, to their church. So you can do that as well via TOD or POD, or the power of attorney can do that as well. Ladybird deed form can, so our platform in particular, the Relax Estate, we do quick claim deeds. We'll talk about the difference between a ladybird deed and a quick claim deed. But from a tax standpoint and from from a tax standpoint, from a cost, because with the deed, you have what you call a cost step up base, which I'll get to a little bit later. But long story short, we recommend a person doing a quick claim deed in our platform, the Relax Estate. If anybody uses our platform, then definitely you can do that right there on the software. Does the POD or TOD prevent the assets from being frozen? So no, the assets are not frozen because we made the election before they were frozen. So assets are frozen when I have no beneficiaries on it, right? Now, in order to move the money from me being the POD or TOD to me getting the money, I have to have a few documentations. Number one, I need my death certificate, right? Because you need a death certificate. Number two, you need ID. So like for us, our investment firm we need your ID, or passport, and then also your social security card. So there's typically two forms of ID and a death certificate. Once that happens, then the bank or the financial institution will automatically move the money, or they'll open up an account in your name first because they want to keep the money there. Now, you don't have to keep money at that broker's firm or that financial institution, but they will open up an account first to move the money over from the person that has been deceased into your account. And then from there, you can take out the money however you want to. So it's not like a snap of the fingers where you get it. Typically, we tell people it's a 3 to 4 week time frame, because it does take banks and financial institutions time to move it. They have their own claims department. Every bank Every financial institution has their own claims department, by the way. So, they all do things different. But if you have a POD or a TOD, then what is needed for you to receive the money without going through probate, which is so important, is death certificate. That death certificate, your driver's license, or passport, and then your social security card. And there'll be forms you have to fill out, then they'll automatically transfer it over. From a tax standpoint, have the tax exemption of under if you're single, a person single and they have $22 million or less, then they will not be taxed from a federal tax standpoint because we have a federal tax exemption. If it's married, then it's $39 million or less. Most people don't have $39 million. Let's speak it into existence. Not so we're not going to pay any federal taxes on that. We have to report it. So the money that you do receive, you have to report that income to the IRS because the IRS wants to know what's all's going on, right? But you don't have to pay taxes on it per se. Now that's receiving it. Now, when we sell, if it's an investment, if we sell something or if it's in cash and we're making interest, then we do have to pay taxes on the interest that we made. Just like if you have a savings account at the bank, everybody got a 1099 these past few months on your checking and savings account. Even if you only made a couple of dollars, you still had to pay taxes on that. So going forward, after you receive the money, you have to pay taxes, but the initial transfer, you do not have to pay taxes. So what happens if I don't have a power of attorney in place and I become incapacitated? Well, three things. Number one, without a power of attorney, you become incapacitated. You're able to make decisions for yourself. Maybe necessary for a family member or loved one to kind of establish a guardianship or conservatorship, right? Kind of what happened to Britney Spears, conservatorship. Another reason why, having things in place with a will and a trust to support him is guardianship. So, let's say a person's single and maybe father, maybe mother's not around. Who's going to take over the children if the children are under 18? We don't want the court to decide that. But if we have a power of attorney, the power of attorney can step in and legally, take over the children, make sure everything is all squared away, having the court say that. It might be friction between one side of the family and another side of the family. Right? We don't want the court to step in and say who gets what. We want it to be within the family and have them agree. Instances like that, if it's a single mother or father situation, very important to have a power of attorney in place. Even if you're 20, 21, 22 years old with a child and you aren't getting along with the other side of the family, it's very important for everybody, no matter what age, to at least, worst case scenario, have a power of attorney for instances of like this. Because we know the court system is taxing and it costs money, which we'll talk about as well. Limited control. So if something is court appointed, especially your guardian, the guardian or conservator is in place, then some financial and healthcare decisions will be left in limbo. And since you are guarding the conservatorship, if you don't have maybe the assets to pay things, you're not able to go into their account because you don't have full power of attorney. You can't go into their account and use money to help pay things. So now how a bill is going to get paid? How is healthcare bills going to get paid if a person's sick or incapacitated? Just because you have guardianship for the children or conservatorship of what's going on from a business standpoint, if you don't have access to the funds, that hurts. Or you use your own money. If you don't get that money back when the person passes away, then you kind of use your own money and you don't get any reimbursement. So again, very important to have that power of attorney in place. And also legal. I mean, think about the cost of going to court, having to take off work, documentation, talking to an attorney, finding out which attorney is the least expensive, paying attorneys. It's very expensive, very, very expensive. We know the court system's not cheap. Attorneys are not cheap. So those are some things that happen if we don't have a power of attorney in place and something happens when they become incapacitated. So very, very important. So how to ensure my power of attorney is recognized properly? So use the right form. So as I said, you want to use appropriate power of attorney form for jurisdiction. Now, every state, very important as well. Like you just don't want to go to, I don't know what website, but you don't want to just kind of just create a power of attorney that's done. Every state has what you call state statutes. So it's very important that if the person is in a different state, we have the right power attorney paperwork for that state. If you have like a template now with us with the relaxed estate, everything is state specific. So anybody who uses our platform, everything's state specific except for Louisiana, but every other state is state specific. But it is very important to make sure that we use the proper documentation because we don't want to have power of attorney, it gets contested and it's wrong and then it gets thrown out, right? We don't want that to happen. Also, if we're going to the hospital, we don't want to use the durable power of attorney or the financial power of attorney for something that's medically related, right? Or we don't want to go to the bank and use a healthcare power of attorney for something that's financial related. So we want to make sure the right forms are being used. Be specific, clearly define the powers as granted. So again, if we have a power of attorney, if we have it within the trust, we can also state what powers that the power of attorney has. In our documentation, you can also state what powers, because you might say, hey, I want from a financial standpoint, the power of attorney to be able to pay bills, but I don't want them to take money out of my account to them personally. I just want them just to pay bills directly to a person. So you can be specific and specify what financial powers and what medical powers you have as well. So here in Florida, it happened about 15 years ago. We had Terri Schiavo. They did not have a power of attorney. And with Terri Schiavo, one side of the family would keep them on life support. One side of the family did not want to keep them on life support. She was on life support for like 7 years. The family had, millions of dollars, and that millions of dollars basically dwindled away in care because some part of the family, there was just kind of arguing back and forth, which is horrible. But, I guess her well wishes was to keep her on life support. Other family didn't want to drain the money. So it was just court proceedings back and forth. She ended up passing away, but it was millions of dollars of her estate that was gone. Now that was her well wishes, and that's her well wishes. But if a power of attorney was there, then it wouldn't have been national news because everybody knew about it. Everybody knew the family situation. I'm pretty sure the family dynamics would never be the same. But if a power of attorney was in place, that would have. So it doesn't matter if you're, 65 years old or 18 years old. We always recommend everybody at least the least thing that you should have is a power of attorney. And also notarize the documentation. You have to have the document notarized. You have to have the power of attorney notarized. If you just have it done, take it to the hospital, take it to a bank, it's not going to work. So it needs to be notarized and typically has to be having 2 witnesses as well. I know our documentation, it's 2 witnesses. It's in some states you only need 1 witness because again, everything is state specific. Some states it's 2 witnesses. So you have a notary and the witness. You have some states where it's 1 notary and 1 witness. On our documents is 2, but you want to make sure it's state specific as well. So yeah, that is a power of attorney. I know I'm getting deep in power of attorneys, but power of attorneys is very, very important. And it's kind of the foundation of setting up a trust will and a power of attorney estate planning package. All right. So a will. All right. So now we're going to talk about a will. So you have 2 types of wills. You have a last will and testament, and you have a pour over will. Now, a pour over will is only going to be in a trust document. A last will and testament is going to be in a trust document and just by itself. So the will, it outlines your wishes for distribution of the assets after you pass. So basically it tells the world who gets what when I die. Also, it covers naming of the guardian. So if I'm a minor, and again, I want to, if I'm not married, and I'm not, whatever happens with the father or the mother, it kind of talks about who is the guardian of the minor, gets the assets, and then also funeral arrangements, what happens as well. And also it goes through the probate process, which involves court supervision. It's time consuming. It's costly. It's a headache. Probate's horrible. I mean, there's no other way to put it. Probate is a way that the county makes money, and it's a way that a lot of lawyers make money. But we definitely want to make sure we do anything and everything we can to bypass probate. It saves money for your beneficiaries. It saves money for everybody, and it's so much headaches that's involved with probate. It's just and I mean, I have clients, for whatever reason, don't do, even though we have our platform, that they don't do trust. And, so I'm getting calls from attorneys, send this documentation. People are fighting. We get subpoenaed to send stuff over to make sure, how the money was spent. Cause they're saying, hey, daddy was spending money on you and that should have went with us. It's just a mess. It's arguments. It's just a hassle. So we want to bypass probate. Pour over will is in conjunction with the trust. So you have a pour over will if you have a trust as well. It's a safety net for assets that you may have forgotten about when you do your trust. So if you do a trust and you forgot a year or two later that you bought another property, or you forgot about that property that you had and you didn't put into the trust, the schedule of assets, then it's a safety net saying, hey, the stuff that you had or forgot about, it pours over from the will to the trust. So that has the potential of bypassing probate. Now, if you don't have a quick claim deed, then it's still going to go to probate. But some of your assets, it does allow it to avoid probate because it's a pour over will. It also directs any assets not already in the trust to pour over into your trust upon death, as I talked about, right? So what is probate? Probate is the legal process where a court validates. So not you, whose money it is, not your clients, but the court, a person banging a gavel, he or she makes the decision of the person who passed away, and they oversee how the money is spread out. So even though you might had a power of attorney and you said, hey, power of attorney, make sure XYZ happens. Okay. And you might have a will that say, make sure XYZ happens. Okay. But the court still decides. The court is overriding, right? They decide. So you might have something totally different in the will, but if other people contest it and the courts think otherwise, then they actually make the final decision and they bang the gavel. It is no way, no one wants the court to decide who gets their money. And if I put in a legal document like a will, the court can still decide who gets your money. Nobody wants that. So, having a trust supersedes probate process, but probate is there. Probate is very expensive, you guys. The average probate court cost is on average 4 to 7% of your total estate value. Meaning, if I have $500,000 estate, that could be 20 to 35,000. That is a lot of money. Municipalities make thousands upon thousands of dollars over the course of time, millions upon millions of dollars on probate. Every $100,000 I have, 5 to 7,000 goes to the court system before my family gets a dime. So when I do my will, I think that I am doing a good deed because I'm telling everybody who gets what, but I'm not. So the reason why a trust is so important is because it bypasses probate. Now, the reason why a lot of people don't do trust is because they look at trust being expensive. They want to pay $2, $3, $4, $5,000. Well, that's an expensive. If I have a $500,000 estate, not including attorney costs we'll get to, but if it's 5%, that's $35,000. I'd rather pay $4,000 to get my trust done now compared to pay $35,000 later. Now, a person might be thinking, well, I'm not paying for it. I'll be dead. But you are paying for it. Your money's paying for it, right? Because they liquidate the estate and then the money, that 35,000 leaves and goes to the court system. So it's your money anyways. So rather as of being alive, you're $3, $2, or $5,000 to pay for a trust compared to your, $30,000, $40,000 down the road to pay for probate. So probate is very, very, very costly. Very, very costly. So probate's very expensive, right? What's included in those costs? You have court filing fees. Now, I didn't get to the attorney fees because typically an attorney on the low end is going to charge, this is on the low end, an hour in retainer. On the high end, $500 an hour in retainer. So it's going to be fall somewhere in between that. What the attorney is doing, and typically their retainer is usually 20 hours up front. So if they're on the low end, now they keep it in escrow. So if they only do 10 hours, you'll get that money back. Let's just say, for instance, they charge $250 an hour and you have to pay, like I said, 20 hours up front from retainers to put in escrow. That's $5,000. That's $5,000 that I might not be able to take from the trust to pay for it, right? The estate, because it's in probate. That means we have to scramble as a family to pay the attorney. What even goes into probate, and I don't know how I'm gonna get the money. because the judge might say something otherwise, or in that will, I might not be able to have access. So I paid all this money. The person who gets the money, they don't have to pay me back. They don't have to. So a lot of times you see things stuck in a state where that means ain't nobody putting a claim on it for years. That's why we see a lot of, you know, tax sale deeds, or, you know, family members are arguing about who gets what, when they get what, but nobody does anything. And now the municipality or the state puts it up for auction. You have a certain amount of time to get this out of probate or to pay the taxes that are past due. Nobody does it. The state takes it, and now somebody else, an investor, buys it, and now it's their property. Personally, you know, my family is going through this right now in North Carolina. We have a family property on my grandfather's side in Hendersonville, and we just have family kind of just bickering. It's basically nobody wants to kind of pay for. At the same time, they got to pay taxes, and I've been paying taxes on the property for the past 4 years, just because, you know, family's bigger because nobody wants to spend the money to get it out of probate. So yeah, so this happens all the time, and a lot of people lose their family lose the property because of it, because back taxes aren't paid, or you have blight where it's a house and nobody's cutting the grass, and now you have bushes, and you know, and it gets taken over because you're not paying the fines by the city. It happens all the time. You have a real estate investor come and you know, and buy it for, you know, $5, $6, $7,000, pays the $5,000 of back taxes. So they got a $15,000 house. They fix it up, sell it for 100,000. The family gets nothing. So having things in place, stops a lot of issues that we have with probate, like having to trust. For whatever reason, people don't do it. So yeah, I know I got off on a tangent there, but it's having to do with my family, my extended family, not personal family, but extended family though. So yeah, but I'm paying the taxes though. We want to keep it the family, but it's just a mess, just a mess. Appraisal and accounting, miscellaneous legal fees. If there's no will, then the court follows state or decide who inherits it, and that's called interstate succession. So if there's no will, then basically the court decides, but it can still be contested because a will can be contested. Now, navigating out of state probate. Now, this is very important. Very, very important. If I have property in different states, even worse, because now I'm paying money on two fronts. So I'm living in Florida, and I have property, in Pittsburgh, in Pennsylvania, right? So if I didn't, which I do, of course, if I didn't have a trust and everything deeded, something happened to me, then that means my wife and family have to deal with probate in Florida, and they have to deal with probate in Pennsylvania. So that's more money, which means more attorneys. Not funny, right? So you have ancillary probate, right? And that's required. Ancillary probate. That's if the person who passed away has property in multiple states, a probate in both their home state, as I talked about, and also the other state as well. Each state has its own laws because we have state statutes. So every state has their own statutes. So we have to abide by different state laws. That's why it's going to be two different attorneys, because most attorneys, you know, aren't licensed in non-neighboring states. Like you know, attorney here in Florida probably won't be licensed an attorney in Pennsylvania. So you're going to be paying more. So that's another $5,000 of a retainer you got to pay up front. Yeah. Every state has different rules, timeline, fees equals legal costs, and assets can be tied up. So until both probate processes are complete, the beneficiary may face delays. Another important part: when probate is happening, nothing gets distributed until all the probate is done. Because, as I said before, you have your creditors or people that you may owe. You know, they have to finalize in every single state, because each state has different state statutes. So how creditors can or cannot be able to get money from a person that's deceased, it depends on different states. So it might be a probate friendly state that's done with probate per se, a non-probate friendly state that's not. Well, me as a beneficiary, I can't get the money until everything is all done. That's why probate takes so long. And I use the example of Chadwick Boseman, Black Panther. He went through probate for 2 years. He had, when it's all said and done, about $3 million of assets. Didn't have which is crazy to think about, didn't have a trust. And this is a person that talked to lawyers all the time with his deals for the Black Panther and other movies he had, didn't have a trust, had a will. Well, his will said everything goes to his wife. Well, his parents contested the will, said, hey, all the money that was invested for him to go to acting classes, for him to go to Howard, all the money that was used for him to get to the point where he started making money in Hollywood was because of us. Him and his wife was estranged. I don't know if they were or not, but that was their argument for their attorney. So even though the will said that the wife gets everything, the judge said otherwise. The judge said because of the parents putting so much money invested in Chadwick Boseman when he was married to his wife, they have to split everything. So I'm sorry, the estate was $4 million. It's not $3 million. It was $4 million. So when it was all said and done, they literally had over $1 million in legal fees and court costs. It's California, so California is expensive anyways. $1 million in legal fees and court costs. So now that 4 million went to 3 million. So $1 million gone. 25% of what he worked hard for gone. And then the other $3 million was split half and half between Chadwick Boseman's family and Chadwick Boseman's wife. Even though the will specified everything goes to the wife, the judge said otherwise. So probate is not a all it be all. If I have my will, what says goes. No, the judge decides. So case point. Trust versus a will, and then we'll kind of go over trust. Avoid. So you avoid the time consuming potential cost of probate. Probate on average is anywhere between 6 months and 2 years. I've seen with my own client, probate was 2.5 years. They had property in 3 different states. They had a will. I don't know why they knew a trust with us, but they had a will, not a trust. So it was a lot of moving parts. It took almost 3 years. A lot of money too. A lot of money. So it's just time consuming. And think about if I'm the beneficiary, right? Or if I'm the executor of the will, and I gotta have to kind of help make sure whatever happens goes because I'm the executor or the co-executor. That means I am mentally stressed out for a very long time, having to go back and forth to different courthouses, having to talk to an attorney. Each time I talk to them, they go nickel and if I talk to an attorney for 10 minutes, they go nickel and dime me, or retainer. I got to talk to this person. The family wants to know what's going on. The children wants to know what's going on. Money needs to be made. Where I'm going to get my money? Like that mental stress is not worth it. And, doing a trust bypasses 99% of that. Why put your family, why have your clients put their family in that position if you don't have to? Just do a trust, in my humble opinion. Privacy concerns. A trust is private. A will is public. Everybody knew Chadwick Boseman had $4 million. You had Twitter and social media saying, man, the Black Panther only have $4 million. That's what they do with his money, right? So everybody knows what you have. Everybody knows. So we want to make sure it's private by doing the trust, but a will is public record. Incapacity planning. You can manage and distribute your assets if you become incapacitated. Having a will helps state that, but it still goes through probate. If you have a trust, you can dictate to the power of attorney while incapacitated what the power of attorney can or cannot do outside of the realm of the power of attorney document. So very, very important. Asset management. Manage the assets and businesses. It's something that's through probate, right? There's no management going on. So if I have an investment account is kind of doing what it does, right? But if I had a trust, as everything's kind of going through the process, then, the trustee, the successor trustee, the co-trustee is making sure everything is managed properly before the money's moved over to who it's supposed to. So again, with the will, everything is frozen. That could be done. So for instance, right, the market's been going down like crazy. Now it will recover. So the market will eventually recover. And my personal, now past performance doesn't guarantee future results. As a certified financial planner, personally, I think the market's going to recover by the summertime. Will that be June? Will that be August? I don't know, but we think the market is going to recover soon, not like end of the year. But as the market's going down, right? If I wanted to get out the market, but I'm incapacitated, pass away, it is what it is. The market's going down. My investments are going down. I'm losing money. It's less money to be passed down to my beneficiaries. If I had a trust and I put in this, in my trust documentation, my successor trustee can make sure as things are being moved to my beneficiary, they make sure the investments are going accordingly. Then they can then be the ones that make sure the financial advisor, or if I have a personal brokerage account, changes are being done, right? So I'm able to protect my money as well, having a trust. I really can't do that with the will because everything's frozen. Control over distributions. You have more control when assets are distributed to beneficiaries. You can say who gets what when. And blended families. Now, this is very important, and I act as a financial advisor through this situation right now. So again, this is real. So family had the husband pass away about 3 years ago. Spouse passed away about 6 months ago. Going through probate now. Well, they did not have a trust, right? So, and the property was in each other's name from a deed standpoint. So spouse, husband had two children, previous marriage, not his children with the spouse. Spouse, 3 children, right? No previous, so no children together, all from previous marriages, relationships. They were married for like 15 years. Love is in the air, but everything was kind of separated. The beneficiaries with their investments in their IRAs were, but not not from a trust standpoint, and they didn't do a quick claim deed to put it to a trust. So what happens? And a POD stands for power on death. POD stands for power on death. So what happens? Well, when the spouse passes away, then everything goes to the female, right? She receives it. Female passed away, is going through probate now. Guess what? Now, even though the house they got together, right? They got the house together. Now, since the female passed away last, the 3 kids are going to end up getting the property. So the spouse's 2 children, the male, his 2 kids, they are contested as we speak, saying, hey, that's not fair. They bought this house together with both their money. Why is it? And because my dad died first, not his new wife, why is it that they kids get this $500,000 house? And even though my dad was putting his money that goes to us, we don't get a piece of this. Now, I don't know what the probate court's going to say. I don't know. But technically by law, it was the female who passed away house because he passed away. And so to have a will, by law, it goes to your next of kin. And if your next of kin is your 3 children, not your stepchildren that wasn't adopted, they're not blood, not stepchildren, but if this is your house, and by law, your house goes to your 3 kids, then it's a possibility the other 2 kids from the father who passed away years ago, they won't get nothing. That is why it's important to have a trust. And because of life, blended families are happening more and more. That's just the nature of life. You fall in love, fall out of love. It is what it is. Having a trust would have been able to dictate, hey, if something happens, this gets split 5 different ways. So now when everything is done with that $500,000 house, everybody gets $100,000 a piece. There ain't no bickering. There ain't no cost. There ain't no what you said, what I said. There ain't no arguments going forward. It's a clean split. The importance of having a trust and a will and a power of attorney, you can't put a price on. So spending $2,000, $3,000, $4,000 on a trust is worth it. And believe you me, if the spouse or the wife that passed away would have known in heaven looking down what's going on, they would have wished they did a trust. The 2 children who looks like they won't get any of their father's house. Now they got some assets from his okay, but house is another $100,000 of money that they're entitled to each that they're not going to get. That's not right, in my opinion. So who knows what the court system is going to do and why they're arguing. It's money being involved. So if they lose, it's money they're never going to get back. If they win, they get something, but they don't get everything because they spent the money. It's unfortunate. So using that example is why we say you want to get a trust. So yeah, so cool. All right. So we're going to just kind of talk about trust here. Just kind of overview of a trust. And if you have questions, let me know. Right. So a trust. So what's the origin of a trust? So a trust also dates back to the 12th century in England during the Crusades. So they were first created because knights, they basically kind of went out to fight during the Crusades. So they wanted to have a trusted person to know if something happened to my property that, a person will take over it, right? Or if I come back, then I'm able to take over my property after the fact. So trust have been around for a very, very long time. And then of course the concept evolved in English common law in Louisiana. So we have our estate planning platform, the Relax Estate. The reason why we don't have it today in Louisiana, because Louisiana doesn't go by English common law. They go by Napoleon law. And Napoleon law has parishes and a little bit different. So if you use us, our platform, we don't have it today in Louisiana, which is the only state, but it's English common law. It became a foundation for our estate planning and asset protection worldwide. Modern use today, trusts are widely used in the U.S. for probate avoidance because a trust, theoretically speaking, bypasses probate, voids probate. You also use it for tax planning because you're able to pass down assets without being taxed. Asset protection, you're able to protect assets that is in the LLC inside the trust. So you're protecting yourself from creditors inside the trust, and also just a way to pass down generational wealth from one to another. What is a trust? A trust is a legal arrangement that lets a third party, which is the successor trustee. So if it's a joint trust, you have what you call co-trustees, right? So it could be husband and wife, they're co-trustees, right? They can make decisions on each other's behalf. One person passes away, then the co-trustee is a trustee over everything. And then the third party is the successor trustee. I'm succeeding the trustees, making sure that what the trustee said goes. Those are successor trustees, and they manage the assets on the behalf of the beneficiaries. So the successor trustee can also be the beneficiary as well. Sometimes a person might let me have the successor trustee as my brother, and my brother makes sure that it goes down to my children, which is his nephews and nieces, right? So you can have that, uh, put in your trust. I said yawn. That was a long yawn. It avoids probate, so you control how the assets are distributed and you protect wealth over generations. You have a trust agreement that outlines who gets what, when, and how. And also it could be revocable or irrevocable. Now, a revocable trust, me personally, revocable trust, we recommend with our estate planning platform, the Relax Estate, we only do revocable trust. The reason why I personally want to do an irrevocable trust is because once you do it, you can't make any changes. Where this is happening right now in a negative way with Rupert Murdoch. Not being political, but Rupert Murdoch is the owner of Fox News, and Fox Soul, and just Fox in general. And also Tubi. Believe it or not, Fox owns Tubi. So for all y'all like the black Netflix, as people call Tubi, he actually owns Tubi as well. But some of his children he wanted to take out of his trust because they don't look in the same eyes as he does political. They're basically liberal, and he's, of course, conservative. So he wanted to take them out of the trust. So he went to the court of Nevada where he set his trust years ago and said, hey, I want to kick these people off of my irrevocable trust. Well, the judge decided, no, you have an irrevocable trust. You can't make any changes to this. And you said if something happens, they get a part of your trust, nothing that can be done. So if he had a revocable trust, he could have just made a change to it, had it amended, which means a person notarizes it, and then could have took his children out of that trust. So I don't recommend an irrevocable trust. The reasoning and attorneys do an irrevocable trust is because a irrevocable trust has more tax advantages than a revocable trust. However, with the federal government, as I talked about before, you have the federal exemption from a tax standpoint. If I am married, I can pass down under $30 million or less and have no federal estate taxes or the death tax that people talks about. So if I got less than $40 million and I'm married, I don't need to have an irrevocable trust because I have the same tax advantages. If I'm single and I have less than $23 million, then in a revocable trust, everything passes down with my family not paying any state taxes when it gets passed down. In my opinion, there's really no reason to do an irrevocable trust. Now it's a way for the attorney to make money because they basically do another irrevocable trust. Then they transfer things from one irrevocable trust to another after it's created. So they make money doing that. So it's a great cash cow for attorneys. But me personally, in my humble opinion, I wouldn't recommend unless a person is like Scrooge McDuck, swimming in millions, hundreds of million dollars of money. There's really no reason, in my opinion, to do me personally. If I have siblings that interested in a trust to heir property, but wanted to rent the property without doing the LLC, how would they be protected inside the trust? Okay, that's a great question. So the trust is for distribution, meaning that if something happens to you, who gets the money or who gets the house without going through probate? So it's a way to kind of bypass probate. From a rental standpoint, inside the trust, you can say, because in the trust we created, we have additions and restrictions. You can say, when I pass away, this property cannot sell. You have to keep it in the family and rent it out, and the rental proceeds go to whatever beneficiary you decide. So inside trust, you can say if you want the beneficiaries to sell the house or not sell the house, or they have to come to a 100% agreement to sell the house, or they have to come to a 100% agreement not to sell the house. So that verbiage you put into the actual trust. As far as an LLC, I, as a protection standpoint, always recommend if you have a rental property, you always put that rental property in a separate LLC to make sure that if somebody sues you, they can't go after everything that you have. They can only go over, the bank account that's associated with that LLC, right? So if you're collecting rent and the LLC, you got $4,000, they can go after that, but they can't go after your bank account, your investment account, and everything. I always use the example. I had a client who lives in Georgia. He had property in Wisconsin. People who was renting out the property, they had a government pincher. It bit the ankle of a FedEx worker. He was out for 8 months. He sued them. And, since it wasn't the LLC, it was in his name. They went after him. He had to pay them a judgment of $80,000. He had to take that $80,000 out of his 401k, right? He had to pay back his 401k. He missed out on market growth, all because he didn't have it protected in LLC. If he had that property in the LLC, he would have paid about $10,000, but not $80,000. So I always recommend if you have rental property, put it in the LLC, and that LLC will then be under the trust. So a trust fund guide, very, very important. If you do have a trust, you have to fund the trust. Just because you create a trust doesn't mean everything sticks. It's the end all be all. You have a trust funding guide, which we have in our documents, that says exactly what to tell the banks. So, that bank that has that POD, that power on death, how the trust should be categorized to make sure that if something happens, it's in a trust and avoids probate. If it's a TOD, how to have it categorized. If it's a life insurance policy, right? If you want to make sure the trust takes over the life insurance so that the trust dictates how the life insurance is given out, you want to put the beneficiary if you want the beneficiaries just to get the money with the life insurance and do whatever they want and have it bypass the trust, then you want to keep the beneficiaries of that life insurance policy as the beneficiaries. But the trust funding guide tells you how to fund it, and it's very important. Every asset that you have, to make sure that it's in the trust, that the trust is actually funded. And of course, that's something that we help with. Also, retirement plans, very important, right? Retirement plans are like traditional IRA or a 401k in particular. That money is tax free when it's first moved over. So if I'm a beneficiary of a traditional IRA, it's $100,000. When it first gets moved over to me as a beneficiary, I don't pay any taxes. Now, once I take out the money, I have to pay taxes. But that initial transfer is tax free. Well, if I put as the beneficiary, it becomes a taxable event before I get the money. So not a blanket recommendation, but with me and my clients who have trust, I typically recommend not to put their beneficiary as the trust for their traditional IRA or their 401k because the taxation happens up front. What I recommend is in the trust verbiage, you say, hey, successor trustee, make sure that they don't spend all my 401k. They spend like I want them to. Now they don't have to because the money's in their name, but it's documented. Hey, I want you to spend this 401k money this way. But again, me personally, not telling you what to do. I don't tell my clients to put their 401k, their traditional 401k or their traditional IRA into the trust. I recommend separate beneficiaries. Now, if it's a tax-free account like a Roth IRA, that's different because when you take money out of a Roth IRA, you don't pay taxes. So you can have the beneficiary as a trust. There's no taxation, and then the trust dictates the money. That's different. But on a taxable retirement account, like a annuity, like a traditional IRA, like a 4K, you might want to have the beneficiaries, not the trust. So just kind of food for thought there. Let's see here. More equipment. So what's a quitclaim deed? The last thing. A quitclaim deed is a legal document, as I talked about before, which you say, I have one thing, I want to put it into another person's name. So what we do with the relaxed estate, we have a quitclaim deed where you set up your trust and then you change the ownership from you to the trust. Now, we get the question all the time, does that mean I have to pay my mortgage if I still have a mortgage? No. You still have to pay your mortgage just because you changed ownership from you to you and your trust. That does not stay the same. I mean, that doesn't change. You still have to pay your mortgage. That does not change. But very important, you need to, very, very, very important. You need to make sure with the quitclaim deed that it is filed, because if we do not file that claim deed and we have our trust, it doesn't matter. So we have to file the quitclaim deed with the clerk of court. So basically saying, yes, I have a trust, but now my property is in the trust. If you have two different properties, then you need two different quitclaim deeds. So it's very important. We see a lot of times people do a trust and they don't do the quitclaim deed, so it still goes through probate. So that is very important with the quitclaim deed. Very, very important. We got to make sure that we actually do it, because if it's not done, then it is what it is. So yeah, so that is the quitclaim deed. And then how to avoid probate. As I said before, we first do the trust and then we change ownership from you to you and your trust, and you'll be all squared away. Also, as I talked about, you still better pay your mortgage. If you have a debt, you owe somebody when it comes from a mortgage standpoint, or you have somebody first position, like you did a hard money loan, you use your house as collateral, and now you did a quitclaim deed, you still got to pay them. Just because you deed it to yourself, you still have to pay your mortgage. Also, very important, we recommend everybody, once you do the quitclaim deed, you also notify your mortgage company. They don't make you pay off the mortgage. I know that's a myth. Oh, I got to pay off the mortgage. It's called the St. Germain Act. It was passed in 1982. I remember it vividly because I was born in 1982, right? But the St. Germain Act says that if you change ownership, they cannot make you pay the full mortgage, right? Because when trust was being prevalent, people was doing trust, and then it was a way for the mortgage companies to make you pay everything, make you pay your full mortgage because you changed ownership from a deed standpoint. With the St. Germain Act, you can change ownership from you to your deed. You don't got to pay off the full mortgage. You can still pay them, but I recommend let them know. Also, I also recommend letting your insurance company know as well. Again, that won't change. It won't change anything, but definitely let them know that yes, instead of the deed being in my name, now it's in my name and my trust name. Just let them know. They're not going to increase the premiums. Not going to change anything. Same as the LLC. If I change from my name to the LLC, they're not going to change the premiums, but it's good to let your insurance company know that as well. But very important though, let the insurance company and your mortgage company know that you did a quitclaim deed. They're not going to increase anything. It doesn't have to be paid off, but it's always good to let people know that. Well, so yeah. So cool. Yeah. But we're here, in my humble opinion, because the Lord woke us all up this morning. So I want to give glory to him so we can bow our heads and say a prayer. Hey, Lord, thank you for your love. Thank you for your blessings. Thank you for allowing us all to be here. May everybody on this call, may their friends, their families, their clients, their loved ones, people that they care about, may they be blessed. May you bless our country. May you bless the world. May you continue to touch us. Thank you for being here. We know we celebrate Easter. You brought Jesus Christ down here for us to die on the cross for our sins. We just want to say thank you. We want to say thank you for all the love that you bestow upon us and all the blessings you continue to bestow us and upon our families. May you continue to touch us and bless